The verdict form said guilty on page 1, it said not guilty on page 2, same form, same case, same jury, four-person signature on both pages. Docket CR-2014-11382, Harris County District Court, Houston, Texas. State of Texas v. Darius Welch, one document, two contradictory findings, both signed by a man named Clement Osei, and nobody read page 2 aloud in open court. My name is Lawrence Bream. I spent 14 years as a public defender in Harris County. Texas Bar number 22-5917. I handled somewhere between 200 and 300 cases, depending on how you count continuances and severed charges. I've had clients walk out of courtrooms crying. I've had clients led away in handcuffs while their mothers stood up in the gallery. I have watched families sit in those wooden benches for 3 weeks and then disintegrate in 10 seconds when the foreperson stands up. I have been in this practice long enough to know that the system makes mistakes, and most of those mistakes are boring. Wrong form, wrong box checked, wrong form number stamped on a file jacket. This was not a boring mistake. This was a verdict form that said two opposite things at the same time. And the only way to explain it requires me to account for a handwritten correction that carries my own pen. I have gone over that correction more times than I can count. I have held it under a lamp. I have placed it next to motions I definitely wrote and signatures I definitely signed. The handwriting is identical, not similar, identical, which means either I wrote it and blanked it from memory completely, which has never happened to me in any other context in my professional life, or there is a version of a document that existed before I put my hand to paper. Neither of those explanations sits quietly. Before I get into the document, let me tell you about Darius Welch. Darius Welch was 24 years old when he was arrested in October 2013. He was charged with the murder of a man named Curtis Haynes. A fight outside a bar on the east side of Houston that went wrong in about 3 seconds. 2 witnesses placed Darius at the scene. One witness said he saw Darius strike the victim with what appeared to be a bottle. The medical examiner listed cause of death as blunt force trauma to the temporal lobe. The prosecution went in with second-degree murder. Our strategy was self-defense plus mitigation. The altercation was mutual. Darius had defensive injuries on his forearms, and there were inconsistencies in the witness statements about where exactly each man was standing when the contact occurred. I thought we had a real shot at the lesser charge, deadly conduct causing bodily injury, maybe even an acquittal on the main count. The jury deliberated for 11 hours across 2 days. On the afternoon of November 21st, 2014, they returned a verdict, guilty of murder in the second degree. The foreperson, a retired bookkeeper from Pearland named Clement Osei, stood up in the jury box and confirmed the finding when Judge Dunmore asked. Serious man, careful bearing. He'd been the most attentive juror throughout the trial, answered voir dire questions in full, complete sentences. I had no particular read on which way he'd lean. He said the word guilty. Judge Dunmore accepted the verdict. The clerk, Francis Adair, stamped the verdict form and entered it into the official record. Darius Welch was remanded. I went home that night and sat with a glass of bourbon and stared at the wall for a while. That's what you do sometimes. You go over every decision you made, every question you asked or didn't ask, every juror whose face you couldn't quite read during closing. You ask yourself if there was one more thing you could have done. There usually is. There usually isn't enough of them to have changed it. I thought the trial was over. I thought the fight moved to appeals. I did not know that the most important document in the case hadn't been read yet. 4 months later, my appellate colleague Renata Spiro was reviewing the trial record to prepare a motion for new trial. Standard procedure. She requested a certified copy of the verdict form from the Harris County District Clerk's office. Francis Adair's office sent it over 2 days later. Renata brought it to my desk on a Tuesday morning in March. She put it face down and said, "Read it through." The form was 2 pages, stapled at the corner. Page 1, Section A. We, the jury, find the defendant, Darius Welch, guilty of murder in the 2nd degree as charged in the indictment. Below, the foreperson's signature. CO's clean and deliberate. Below that, the date, November 21st, 2014. I turn to page 2. Page 2, Section B. We, the jury, find the defendant, Darius Welch, not guilty of deadly conduct causing bodily injury. Below, the foreperson's signature. The same clean, deliberate hand. Below that, the date, November 2014. I looked at Renata. She said, "It came from Francis Adair's office. Certified copy, official seal." The lesser included offense of deadly conduct causing bodily injury is a standard finding on a Texas 2nd-degree murder verdict form. The jury is required to consider it only if they find the defendant not guilty on the primary count. If they find guilty on the primary count, the lesser included section is supposed to remain unchecked. Clement Osei had checked it. He had checked not guilty on the lesser included count and signed it, on the same form where he had checked guilty on the primary count and signed that too. I have been a public defender for 14 years. I have read more verdict forms than I can count. I have never seen a foreperson sign contradictory findings on the same document. I have never seen a lesser included section completed when the primary guilty finding was entered, and I have never seen it happen without someone catching it in open court. Because in Texas, the clerk reads the verdict form aloud. The clerk is required to read the verdict form aloud in its entirety. Francis Adair read the verdict form aloud on November 21st, 2014. She read page 1. I pulled the trial transcript that same afternoon. The court reporter's record of the verdict proceeding. The clerk reads the verdict, 1 sentence. We, the jury, find the defendant, Darius Welch, guilty of murder in the 2nd degree. That's it, 1 sentence. No reference to Section B, no lesser included finding, no not guilty on count 2. The transcript ends with Judge Dunmore asking the foreperson to confirm. Clement Osei says guilty. The judge accepts. Welch is remanded. Page 2 was never read aloud. Page 2 was never entered into the oral record. Page 2, as far as the official court proceedings were concerned, did not exist. I called Francis Adair the next morning. I told her I had a question about the certified copy she'd produced for Renata Spiro. I said, "Francis, the form has 2 pages. She said, "That's correct. The standard Texas form is 2 pages when a lesser included count is submitted." I said, "The lesser included section on page 2 has a finding, signed by the foreperson." There was a pause. She said, "That's not possible. If a lesser included finding had been entered, it would have been in the reading." I said, "It wasn't in the reading. I checked the transcript." Another pause. She said, "Let me pull the original." She called back 40 minutes later. Her voice was different, careful. She said, "I have the original form in my hand. It has 2 pages. Page 2 has a finding. I don't know how that happened." I said, "Neither do I." She said, "This would have been caught. This should have been caught." I said, "When would it have been caught?" She said, "At the reading. The clerk reads the full form." I said, "Francis, who told the clerk to read only page 1? She was quiet. Then she said, "The instruction sheet. The judge's instruction sheet tells the clerk which sections to read." I said, "Can you pull the instruction sheet?" She said she'd look. She found it in the supplemental case file the following day. The instruction sheet for the Welch verdict proceeding listed the sections to be read aloud. Section A was listed. Section B was not. Section B had been crossed out in handwriting in blue ballpoint ink. I went to the clerk's office in person the next morning. Frances laid the instruction sheet on the counter and I bent over it. The handwriting on the crossed-out line was precise. The cross-through was a single diagonal slash. Below the slash, a notation, "See court approval. Minor count waived per defense motion. TX Rule 36.27. I looked at it for a long time. Then I recognized the handwriting. It was mine. I stood at Frances Adair's counter for a long moment. The handwriting was mine. I know my own handwriting. 14 years of motions and marginalia and case notes have made it completely distinctive to me. The way I loop the B and bream, the way my numerals tilt slightly right, the particular angle of my diagonal strokes. A forensic document examiner could confirm it. I didn't need one. That single slash across the section B line, with the notation below it, was written by me. Except I had no memory of writing it. I had no memory of filing a motion to waive the lesser included count reading. Texas Rule 36.27 governs procedure during the verdict proceeding. I was familiar with it, but I had never invoked it in any of my trials. It allows for procedural waivers under limited circumstances, with judge's approval. It would have been unusual. It would have required a formal conference with opposing counsel and the bench before the verdict came in. No such conference appears in the trial transcript. No such motion appears in the case docket. But a notation in my handwriting says I filed one. And if that notation is accurate, if I did file that motion, then I was waiving the reading of a section I had reason to believe would say, "not guilty," which means I had reason to believe the jury was about to return a split verdict before the foreperson stood up. If that's true, why would I suppress it? Darius Welch was my client. A not guilty finding on the lesser count was a constitutional argument we could have made for years. It might have been the difference between him going home or spending the next decade inside. Instead, if the notation is to be believed, I made sure nobody heard it. I drove back to the office and spent the rest of the afternoon going through every document in the Welch trial file. Every motion I had filed, every response I had submitted, every written conference report, every document I had signed. No motion relating to Texas Rule 36.27. No waiver of any reading procedure. No record of a pre-verdict conference with ADA Stacy Holt or Judge Dunmore. I called Stacy Holt's direct line. She was 4 years out of law school, now on her second posting at the DA's office. She remembered the Welch trial clearly. I said, "Stacy, did we have a pre-verdict conference about the lesser included count?" She said, "What do you mean?" I said, "Before the verdict came in, did anyone discuss the Section B reading?" She said, "Not that I recall. We got the verdict and went back for sentencing. Standard." I said, "Do you remember anything unusual about the jury instruction sheet?" She said, "No." "Why?" I said, "Because the Section B reading was crossed out, and there's a notation in my handwriting saying I filed a Rule 36.27 motion." A long pause. She said, "Did you?" I said, "I have no record of it, and it's not in the docket." She said, "Then maybe it was a clerical note. You know how things get written on forms." I said, "This wasn't a clerical note. It waived a procedural requirement." She didn't have an answer. Neither did I. Renata Spiro had filed the motion for new trial based on the verdict form contradiction. The argument was straightforward. The jury had entered a not guilty finding on the lesser included count, which, if credited, created a double jeopardy bar to the murder conviction. The oral verdict was inconsistent with the written verdict. The written verdict controlled. The motion was heard in April 2015. Judge Dunmore denied it. Her ruling was brief. The lesser included finding was a clerical error made after the oral verdict was recorded. Because Section B had never been read aloud, it had not been officially entered into the record. The oral verdict, guilty on the primary count, was the legally operative finding. The written page 2 discrepancy had no legal effect. She was probably right on the law. She may have been wrong on the facts, because a clerical error implies a mistake made after the fact. What Judge Dunmore's ruling did not address was the notation on the instruction sheet, the notation that said Section B was waived per defense motion. A waiver executed before the verdict came in is not a clerical error. It's a deliberate procedural choice. If someone waived the reading of Section B before the verdict, that means someone knew what Section B was going to say. That means someone knew the not guilty finding was coming. That means the verdict was anticipated, not as a possibility, as a certainty. In June of 2015, I tracked down Clement Osei. He was 63 years old, living in a residential neighborhood in Pearland, about 25 miles south of Houston. I called him at the number listed in his jury questionnaire. Jurors was that contact information is available to parties of record for a limited post-trial period. He answered on the second ring. I identified myself. I said I had a question about the verdict form. He said, "I've been expecting someone to call." I asked him about page 2, about the Section B finding. He said, "I signed both pages. That's what the instructions said." I said, "Which instructions?" He said, "The packet we received in the jury room. It had 2 sections. It said to complete both. The form had a line for each count." I said, "The verdict form is only supposed to have Section B completed if you find not guilty on the primary count." He was quiet. Then he said, "The packet said to complete both regardless. It said the court would record whichever finding was applicable." I said, "Can you describe the packet?" He said it was a standard-looking document stapled on court letterhead. It had been given to the jury before deliberations began. It was collected from the jury room after the verdict was returned, along with the other deliberation materials. He assumed it had gone back to the court. I said, "I have the jury instruction materials in the case file. There's nothing in here that says complete both sections regardless." He said, "Then the court kept it separate." I said, "Clement, do you remember who delivered the packet to the jury room?" He said, "The clerk, the woman with glasses." Frances Adair wears glasses. I called Frances Adair again that afternoon. I asked her if she had delivered any supplemental instructions to the Welch jury during deliberations. She said, "I deliver the standard materials, whatever the judge approves." I said, "Is there any record of supplemental materials delivered to jury room 3 on November 20th or 21st? She checked. She came back and said, "I have a delivery log entry, November 20th, 4:47 p.m. Supplemental instruction packet, CR-2014-11382, delivered to jury room 3. Authorized by court clerk's office." I said, "Who authorized it?" She read the name from her log. Elbream SQ, TX bar number 225917. My bar number. An authorization I had no memory of signing. I want to be clear about what this means procedurally. A delivery of supplemental materials to a jury during deliberations is not a minor event. It requires court authorization. It requires notice to opposing counsel. It requires a record entry. It is the kind of thing that, if done improperly, becomes the centerpiece of an appeal. None of those things happened here. There is no court authorization in the file, no notice to Stacy Holt, no record entry beyond the delivery log, only Frances Adair's clipboard entry, my name on the authorization line, and Clement Osei's account of a packet that told him to sign both sections. If I had actually authorized that delivery, I would have known the jury was being instructed to complete Section B. I would have known, before the verdict was read aloud, that the form would contradict itself. And I had already arranged, according to the instruction sheet, for Section B to never be read aloud. I was either running an operation I have no memory of, or someone was running one in my name. The documents don't tell me which. I drove to the courthouse the next morning and requested the delivery authorization log in person. It was a physical log, a clipboard in the clerk's receiving area, one of those institutional binders that every court office has. Lined paper, handwritten entries. The entry for November 20th, 4:47 p.m., case CR-2014-11382 was there. The authorization signature, L. Bream. Same diagonal stroke in the L, same lean in the handwriting, mine, or something that had become mine. I want to be careful about what I'm claiming. I'm not saying I was framed. I'm not saying someone forged my handwriting. I've seen forgeries. I've hired experts to analyze them. This wasn't that. The instruction sheet annotation was my handwriting. The delivery authorization signature was my handwriting. I have been in enough fraud cases to know when someone has perfectly imitated a signature. This wasn't imitation, it was the real article. Which means one of two things. Either I made these authorizations and have no memory of them, which has never happened to me in 14 years of practice. Not once, not in any case. Or the documents existed before I signed them, which means my handwriting was on paper before my pen touched it. I don't have an explanation for that. I just have the documents. And Darius Welch, in a correctional facility east of Houston, serving out a sentence under a verdict that said two things at once, and only one of them was read aloud. The jury said guilty. The jury also said not guilty, on the same form, and no one read the second page aloud. Because someone who wrote like me made sure they wouldn't. And I still don't know if that someone was me. Renata filed a second motion in October 2015. This one targeted the delivery authorization and the supplemental jury instruction packet. If someone had delivered unauthorized materials to the jury during deliberations, the argument ran. Those materials had potentially influenced the verdict. The jury had been told to complete both sections of the verdict form, regardless of their primary finding. That was an instruction no court had approved in a proceeding where the official jury charge said nothing of the kind. It was a solid motion. Renata built it carefully over 4 weeks. She cited 3 Texas appellate cases where unauthorized jury contact had resulted in reversal. She put Clement Osei's account at the center. She attached the delivery log. She did not attach the instruction sheet. I asked her why. She said, "Because your handwriting is on it. I don't know how to explain your handwriting." I told her to attach it anyway, to let the court wrestle with it. She was quiet for a moment, and then she said, "If we put your handwriting on that document, the appellate court might read it as defense counsel tampering with jury procedure. That kills us." I said, "If we don't put it in, we're suppressing evidence." She said, "We're choosing which evidence to use. That's strategy." I let her leave it out. That decision still sits with me. Judge Dunmore denied the motion in December. Her ruling addressed the delivery log, but not the substance of the instruction packet. She found that there was no authenticated copy of the supplemental packet itself in evidence. Only Clement Osei's testimony describing it. Without the packet, there was no proof of its contents. The delivery log, she ruled, was not sufficient to establish harm, and the verdict form discrepancy had already been addressed in the April ruling. The Court of Appeals declined to review it in February 2016. Darius Welch filed a pro se petition the following year. It was denied without comment. He's still inside. In January 2016, I requested a new certified copy of the verdict form from the Harris County District Clerk's office, not from Francis Adair's window. I submitted the request through the formal records office, using the standard written request form. The certified copy arrived by mail 10 days later. It was 1 page, page 1 only. Section A, Guilty. Signed by C.O.S.A. Dated November 21st, 2014. Harris County official seal. Clerk certification stamp. True and correct copy of the original document on file. I called the records office and asked if the original verdict form in CR 2014-11382 was a one-page or two-page document. The records clerk put me on hold. When she came back, she said the original in file is one page. I said, I have a certified copy produced in March 2015 that is 2 pages. Both pages bear the clerk's official seal. She said, I can only speak to what we have in file. I said, is there a document destruction log for that case file? She said she would check. She called back the next day and said, no document destruction has been recorded for CR 2014-11382. The second page had not been destroyed. It simply wasn't there anymore. I pulled my own copy of the March 2015 certified document, the 2-page version Renata had originally brought to my desk. I had kept a physical copy in a personal file separate from the case binder, specifically because I knew it would matter. I still have it. Page 2 is there. Harris County official seal. Francis Adair's certification. Date March 9th, 2015. I also have the 16 certified copy. 1 page, same case, same docket, same form. 2 certified copies, 18 months apart with different page counts. One of them is wrong, or they are both accurate records of a document that changed. I do not know how a court record changes. I do not know how a page disappears without a destruction log. I do know that Clement Osei signed it. I know that because his post-verdict juror affidavit, the standard Texas form that jurors complete for administrative purposes after a verdict, contains this line, in a section asking jurors to confirm their findings. I confirm the jury's findings as entered in both sections of the verdict form, including the not guilty finding on count 2. Clement Osei wrote that, in his own hand, in December 2014, 6 weeks after the trial. He confirmed both sections. He confirmed a not guilty finding that, according to the appellate court, had no legal effect because it was never read aloud. He confirmed it because, to him, it was real. I stopped taking new cases in the spring of 2016. I told myself I needed a break. I told the office I was taking a medical leave. That wasn't entirely a lie. I had developed a persistent tension headache that ran from my left temple to the base of my skull and had been there uninterrupted since February 2016. The doctor called it stress. He wasn't wrong. He gave me a referral to a neurologist and a prescription I never filled. But the headache wasn't why I stopped. I stopped because I had been in that courtroom on November 21st, 2014. I had heard the verdict. I had heard Clement Osei say guilty. I had watched the form go to Francis Adair. I had watched Judge Dunmore accept the verdict and enter judgment. I had shaken Darius Welch's hand and told him we would appeal, that the fight wasn't over, that this wasn't the end. I remembered all of that clearly. And I had no memory of writing anything on an instruction sheet, no memory of authorizing a supplemental delivery to the jury room, no memory of filing a motion to waive the Section B reading. But my handwriting was on 3 separate documents: the instruction sheet, the delivery log authorization, and the notation in the case file, all in connection with proceedings I could not recall participating in. I had been present in that courtroom. That was not the question. The question was whether some part of me had also been somewhere else. In conversations I didn't remember. At a counter I didn't remember signing. Writing notes on paper I didn't remember touching. I did not want to follow that question to the end, but I followed it anyway. There is one more thing. I found it by accident in early 2017 when I was packing up the Welch case file to put it in long-term storage. At the very back of the accordion folder, behind the sentencing documents, was a single sheet of paper I hadn't seen before. No case number, no court header, just a blank sheet with a single handwritten notation in blue ballpoint. Section B, never read aloud, confirmed 11/21. L.B. Lawrence Bream, my initials, my handwriting, my confirmation, apparently written on the day of the verdict, that Section B would never be read aloud. I stood in my office with that piece of paper in my hand for a long time. I did not write it. I could not have written it. It was on paper I had never touched, and my handwriting was on it. I don't know what happened in that courtroom. I don't know what the supplemental packet said or who actually authorized it. I don't know why Clement Osei signed 2 contradictory sections of a verdict form and then quietly confirmed it in a post-verdict affidavit that no one read closely for 6 months. I don't know why page 2 of the verdict form is now gone from the court archives. I don't know why my handwriting appears on documents I have no memory of creating. What I know is this. The jury said guilty. The jury also said not guilty. On the same form, signed by the same man. And no one read the second page aloud, because someone who wrote the way I write made sure they wouldn't. Darius Welch is still inside, and I have a piece of paper that says I knew that was going